So we stay with legal matters because the bail application of 5 men accused of murdering South African musician aka and Tibz, his friend, continue in the Durban Magistrate's court this morning. The court will also hear responding affidavits of the alleged co-ordinator Mziwethemba, Gwabeni and Lindani, Ndimande. Watching this story is our reporter Vusi Khumalo, who joins us now live from inside court. And Vusi, of course, we've been here a number of times. Help us place what to expect specifically today.
Yes, of course, we are expecting two accused by the name of Lindani Ndimande, that is accused number 2, as well as accused number 4, that is Mziwethemba Gwabeni, who is the alleged coordinator of, or according to the NPA and police, are saying that he is the main coordinator who coordinated also plotted the killing of AKA as well as his friend, but actually the main target was AKA. That's according to the police. That's what they have told us here in court today. Those two are expected to reply the affidavits that were submitted by the state when at the start of the bail hearing that took place. Well, today we are expecting those two. We also to say that last week, the 3 accused, accused number 1, 3, and 5 also submitted their representations by their legal representatives. They're trying to poke some holes into the evidence of the state, saying that they are going to try their level best in order to prove to the state that the state's case is very weak, and also trying to ensure that they do get their bail. With one of the accused saying that there were a lot of contradictions in the submissions by the state, saying that at the time of the killing of AKA, one of them was waiting actually for his girlfriend there, so denying any involvement in the matter. But to take us through and also to make a sense of what is really happening here today is our legal analyst by the name of Abigail Gwabeni, who's going to take us through about perhaps what to expect. We know that a lot of things are said last week regarding this bail hearing application. So at the moment, we know that one will say that the battle number 1 was won by the defense in saying that they were provisionally granted an application to have some piece of evidence that is in the country of Eswatini to be used here in this court.
Yes, you'll remember that last week we saw an affidavit which was deposed to by the DPP in KZN, and what is different from that particular piece of evidence when you compare it to the initial application which was made by Mr. Volmarans, of one of the legal counsel representing one of the applicants who will be reading the affidavits today, is that the other one was, yes, purported for Eswatini, but there are manner in which it was supposed to have been acquired. So Advocate Mlocho, number 1, number 5, came last week to say there is a one that it's downloadable from the digital space, which they say if the TikTok pictures were downloaded and filed and form part of the court's information on evidence that was presented or that is in the court's file or in the docket, why not allow the accused person to utilize every piece of evidence that is available to the general public to beef up their case in ensuring that they portray to the court to say the interest of justice permits their release and bail in that the state's case is weak.
Will you say, is there any reason the state is using not using oral representations but opted to use affidavits?
And it's not necessarily the state as such. Remember that in a bail application, the onus rests on the applicant. The applicants are the one who instituted these proceedings, and they elected to go through an affidavit stating factors upon which they say the interest of justice permits their release on bail. So the state only responded through an affidavit, responding to the affidavits that were read in here on behalf of the applicants. But of course, it's either you do it orally or through affidavits, but it does have the same legal effects, noting as well that these affidavits are statements with a legal effect that would be accepted even if it was done through oral.
And perhaps what could be expected today from Lindani Ndimande, that's accused number 2, and accused number 4, Mziwethemba Gwabeni?
we are expecting them to come and speak more on particularly Gwabeni, because he does not have pending cases, and when we had his affidavit, does not even have previous convictions. But now you'll have to come and rebut the strength of the state's case, noting as well that the affidavit of the IO places him in different places on the date of the commission of the offense. It places him at the airport, it places him on passing through the toll gate, following the deceased car in a very short space of time. It also places him as well at the hotel and at the place where, in the vicinity of where the occasion of the offense took place. They also took it further to say it placed him at Umlazi around the same car that was used to commit this particular offense. And it will be interesting to note in his affidavit on how he comes and say the state's case is weak based on this and that, like the other ones have said, poking holes on the state's case.
But surely as well, the other three have already distanced themselves from the killing and also from the plot that took place. So it will be very interesting, as you are saying, that they will try his best to poke into the submissions that have already been made.
Remember that the onus is on them. In law, when they apply for a bail application, they need to come to court and say, on balance of probabilities, there are exceptional circumstances that when you balance them with the interest of justice, they do permit their release on bail. But of course, you'd remember that the Section 60 of the Criminal Procedure Act in subsection 4 lists in factors that when one or more of those is available, the interest of justice don't permit their release on bail. So the ball is on their court to come and convince the court, given that from where I'm sitting, the affidavit of the IO was so detailed that when you have to poke holes and that, it should not be an issue of time to say you went to a restaurant at 10 past and as opposed to half past. Those are differences, but not so much of material differences that you can say you stand here and challenge the state case.
Thanks a lot for time.
I really appreciate it.
Okay, thanks. It's the legal analyst Gwabeni, so saying that today it won't be that long because we are just expecting the two accused to have their say here in court, Ayanda.
Vusi Khumalo is live to us there from the Durban Magistrate's Court. That all-important case continuing today. For now, Vusi, thanks very much indeed.